generally. And to extrapolate that principle from Wilson would be to overturn a whole line of authority, including cases like TVNZ and Preble, where the issue was simply the impact of the conduct. The other thing is that Antonovich and Wilson, which are essentially the same case. Does you want to understand the link between the two cases?
I do, yeah.
Essentially the same case. That was a public confidence case, and what we're dealing with here is, under the July stay application, is primarily, perhaps not exclusively, but primarily a fair hearing issue, not under the fair trial provisions of the Bill of Rights, but under Section 27. So we say that the state misconduct point is a super added requirement which goes beyond what has been traditionally required in fair hearing cases. There is no such restriction in Section 27, subsection 1 of the Bill of Rights, and it's never been a requirement of natural justice procedural fairness points to show that the unfairness had been caused by a state actor. So we say at top of page 154 that the situations considered in Wilson and Antonovich are illustrative rather than exhaustive of the situations where a stay might properly issued. It's misplaced and wrong in principle to construe those cases as circumscribing the law on stays. And if that requirement was essential, then Television New Zealand and Preble would have been decided on a completely different basis. There was certainly no state misconduct in that case. It's just the impact of the situation in relation to parliamentary privilege. And we've got from the bottom of page 154, top of page 155 and onwards, we've got the quotes from the Court of Appeal. Simply the impact of the issue on the fairness of the hearing, and then we deal with the Privy Council case, the Privy Council hearing and decision at page 156. So at 514, we say to draw an analogy with at paragraph 514, to draw an analogy with the present proceedings, it's submitted that the court does not need to focus on establishing misconduct in order to stay the proceedings on the ground of unfairness, the first category. Instead, the question for the court is whether the proceeding is actually unfair. Now we then move to the heading on our page 158, which is other US submissions concerning the test for abusive process. The US submits that His Honour Judge Dawson was clearly right to hold that staying the extradition would undermine confidence in the justice system more than proceeding to a hearing. But they don't, the US, counsel for the US don't quote the full passage, which we do quote at the top of 159. What His Honour said was, whatever advantages it is perceived the United States might have pursuant to MACMA and the Act, are those legitimately available to them. They are not a basis for a stay application. Granting a stay application based on these submissions, with total disregard for the law, is more likely to undermine public confidence in the criminal justice system than it is to proceed with this eligibility hearing to a conclusion. And His Honour has understood incorrectly that we were saying that it was an abuse, that the United States was responsible for an abusive process because it had had advantages under MACMA and the Extradition Act. How His Honour could have reached that view, we simply don't know, because the proposition that he was dealing with is self-evidently absurd, and it was never suggested to His Honour that there was an abusive process because the United States had had advantages. What was submitted was that because the United States, and the same submission has been made in this court, because the United States had come to our jurisdiction and had appeared as a litigant in our jurisdiction and had had advantages, huge advantages in our jurisdiction, that it owed a reciprocal obligation to cooperate with the court proceedings and to facilitate natural justice. That was the submission. And His Honour has completely misunderstood that point. And on the basis of the misunderstanding has said that if he granted a stay on that basis, it would undermine confidence in the criminal justice system. Well, of course it would. To grant a stay on that basis would make a court, any court, a laughing stock. But that was not the basis upon which we advanced the argument. We then deal with the case of Schlesinger, always get that wrong, and we say that case is a valuable guide for the courts. The US tries to distinguish it and downplays it, but the court in that case, at the top of page 160, said there's no doubt that by seeking to put those witnesses in bulk and succeeding in so doing, those involved were improperly interfering with the course of justice. And the court went on to hold, there's little doubt that if the trial judge had been told that defence witnesses had been prevented from coming to court at the initiative of the prosecuting authority, it was highly likely that he would have stayed the proceedings unless there was any possible way of enabling those witnesses to attend after all. Even if the story those witnesses would have supported was one the jury would have been likely to reject, it was the appellant's right to put it forward if they wished. And then the commentary at the end of the report, a defendant does not get a fair trial if he's precluded from calling witnesses whom he believes to be necessary to his defence. Now, Your Honour has to make the necessary adjustments because this is not a trial, it's an extradition hearing, but surely interference or blocking the availability of witnesses should be regarded as a serious issue, as it clearly was in that case. Now, the rest of that section can be taken as read, Your Honour. We move on to 163, our page 163, where the United States says that that Cobb is an extreme case, and counsel will attempt to distinguish that case. But we say what happened in Cobb is directly analogous to the conduct of the US in this case, which is putting unreasonable pressure on requested persons to abandon their defence of extradition. In Cobb, it was by way of threats. In this case, it was by way of obtaining forfeiture of the plaintiff's assets and enforcing forfeiture as far as possible without it having been registered. In other words, forfeiture by the back door, or forfeiture registration, I should say, by the back door. The US attempts to distinguish Cobb on several grounds, and we set out our responses. We simply say that, of course, Cobb is a different situation. Each case, each abusive process case has to be assessed carefully according to its own facts and context, but it still gives valuable guidance as to how the court can view certain conduct on the part of a requesting state as disentitling conduct. Then at page 164, we deal with the contention that there must be a flagrant affront to the legal values of this country. And the US submits that it would require a flagrant affront to the legal values of this country before the conduct of the requesting state could justify a stay. In our submission, Your Honour, that doesn't take the matter any further. If the conduct of the United States has had an impact on the extradition hearing, which affects the fairness of that hearing, that is sufficient to bring into play the principles of natural justice which are affirmed by our common law and by our Bill of Rights. And that is sufficient to meet any requirement for there to be a flagrant affront, which in any event we say is not a prerequisite. In our submission, a breach of natural justice is always a flagrant affront to New Zealand values. As we acknowledged earlier, the requirements of natural justice vary with the context and with the circumstances, but if fairness has been impeded in a real way, then that is sufficient to meet the requirement for there to be an affront. There is an affront in those circumstances. Now, Your Honour, apart from the appendices, that takes us to the end of Volume 1. Appendix A contains the references to the District Court in the United States submissions, and as far as we can tell, sir, those are all of the references, and there is a notable absence in those references to the reasons given by the District Court. Most of the references don't engage with the reasoning of the court, and we leave Your Honour to assess that submission on the merits of the table. Your Honour will see that there is a much larger appendix comprising 79 different passages in Appendix B, which include United States submissions which bring into play US law in their original submissions. And we've given Your Honour the references concerning things that are said to have happened in the US or which bring into play US law. And we say that that table speaks volumes about the extent to which US law is involved, is implicated, if you like, in the extradition proceedings, and the extent to which overseas advice is necessary, and the extent to which issues could be addressed by way of foreign law evidence. And we leave Your Honour to consider that table.
All right. Mm-hmm. Just coming back to Appendix A.
Yes, sir.
Is the, I mean, that's just what you've been able to extract from the submissions advanced on behalf of the United States in terms of reference to reasons. But is it the case that there are other important reasons that have been left out, or
well, sir,
is this partly a reflection of your complaint that there aren't reasons on many of these issues?
What we are saying here...
Or is it a bit of both?
we have said there aren't adequate reasons, and that submission will stand or fall on its merits.
Yes.
What we're saying here is that the US has failed to engage with that issue. It's failed to defend the judgment of the District Court by reference to reasons that have been given. The reason it's failed to do that is because of the deficiency that's there in the first place. Yeah. So this is an illustration of the fact that the US has been forced into what is really an untenable position of saying this hearing can be treated as a rehearing de novo. Why? Well, because the judgment is so bereft of reasons in the first place that if they engaged with the reasons, they would find themselves in grave difficulty. And we say that this table illustrates that point. So, Your Honour, we now move on to our Volume 2, and that starts with Section F, which is the August and September stay applications. I think it's fair to say that I can probably move more quickly through Volume 2 because the issues are perhaps reasonably straightforward. But there will be points where I'll have to pause and explain. So our overall comment on the United States submissions in relation to the August and September stay applications is that the district court judgment is ignored. The district court, the US focuses on the result, but doesn't really engage on the reasons. They say that the district court was correct not to hear the August stay application because the district court had no jurisdiction, or that the proposed evidence could never justify a stay. And we dispute those propositions, and we say that the United States submissions are wrong, and we set out our reasons. We, in relation to issue F1, procedural unfairness and breaches of natural justice, we simply say that, as we've previously explained, the district court failed to deal with the August stay application in accordance with law and in accordance with natural justice. The US provides no answer to the procedural arguments except as set out in our paragraph 7 on page 2, and I'll take you to that. The US answer, note our paragraph 7, the US answer to the district court failing to consider the August stay application can be found in the US response to the case stated. In the question, was I correct to consider only the grounds in the September 2015 application and not those additional grounds contained in the August 2015 application? Answer. The grounds in the August 2015 application were repeated in Mr. Dotcom's September 2015 application. So the question posed by the district court appears to acknowledge that...
Well, it's a self-answering question, really, isn't it? You ask a question like that, permits of only one answer, doesn't it?
Well, His Honour signed it off.
Well, that's right.
But look, we're
was
not
I wrong to get it wrong? It's a bit like that, isn't it? Or to fail to deal with it.
I see what Your Honour is saying.
You can't really answer that question other than, well, obviously you've got to consider the grounds, you've got to consider the application.
Yes, but it amounts to an acknowledgement that His Honour did consider only the grounds in the September 2015 application. That's the point I was trying to make. But look, I don't want to press that point. It falls to be decided on what's in the judgment rather than what's in the question.
Yeah.
And we say that there is no evidence at all in the judgment, no indication in the judgment that the August stay application was considered as a separate issue. So the point we're now making is that the United States hasn't actually engaged on that point. They've simply said, look at Mr. Dotcom's application.
Yeah. Well, it looks like that's the way that the district court judge did look at it, as treating it as being wholly contained within and covered by the application that Mr. Dotcom made.
That's what we say, sir, and we were reduced to a supporting role by that approach. But more importantly, our evidence doesn't appear to have been considered.
Yeah.
So we say that the US hasn't answered our argument on that point, and the answer given is inadequate.
But if the judge was right to strike it out, to look at grounds only, when the judge seemed to accept your submission that he had jurisdiction to grant the stay, seemed to accept your submission that the Bow Street filter should apply, but as you say, put up a sort of the screening and the substantive test together.
Yeah.
And you say didn't then apply it properly. But nonetheless, it's reasonably clear, isn't it, that the judge did accept your submission that Bow Street should apply and that there was jurisdiction.
Yes.
But it seems also reasonably clear, doesn't it, that he confined his attention in the end to the pleaded grounds of those stay applications,
Yes.
concluded that Mr. Dotcom's application was slightly more extensive. It covered all of the territory covered by your client's stay applications, and considered that even if all of those were approved, they couldn't justify a stay, and therefore it was appropriate to strike those applications out. Is that correct? Is that a fair reading of the judgment and what the judge did?
We say there are two problems with that, Your Honour. Mr. Dotcom's application contained 70 pages of particulars,
Yeah.
and that swamped the points that we put up, which were a subset of the points made in those 70 pages.
Mm.
His Honour,
They were all covered, though, weren't they?
well, no, sir. The judge, if you look at the application, the August stay application, it contains headline grounds in the application itself,
Yes.
and particulars that are set out in the appendix.
Yes.
Our appendix was a few pages, maybe 7 or 8 pages. Mr. Dotcom's appendix, and this is not a criticism, was 70 pages. What the judge did was to go through the grounds in the body of the application, not the grounds set out in the appendix. So he never focused on the issues which were identified with particularity in the appendix. So, for example, was appropriate disclosure made in relation to the ex parte application to obtain arrest warrants? We say that there was a failure at that point, that it had a direct connection with the proceedings, because if the provisional arrest warrants hadn't been issued, the case wouldn't have proceeded. Certainly Mr. Ortmann would have left the country shortly thereafter, and that issue needed to be dealt with. Now, His Honour doesn't focus on that issue and doesn't give any reasons in relation to that issue. Similarly,
Well, he didn't really give reasons, that's true. He just announced a conclusion, really, that none of these pleaded grounds could justify a stay.
and the problem with that, Your Honour, is that what His Honour did say doesn't indicate that there was a proper assessment of all of the matters that were set out in the appendix. That might not be so in relation to the grounds in the body of the application, but the appendices in both cases were important.
Yes, but don't they provide particulars of the main grounds?
They do, but they are very important particulars because they set out things like unreasonable search and seizure. There's a whole issue about whether the raid on the mansion constituted an unreasonable search and seizure, whether the arrest warrants were lawfully issued. There's a whole string of different things which could only be considered if they were being considered properly by the judge looking at the appendices. And what His Honour has done is to make a global decision, a machete sliced through the corn, and has cut down those arguments in one fell swoop without giving consideration to the components that made them up. And we say it's not just a lack of reasons, it's a lack of analysis. It's a lack of meaningful judicial assessment in relation to that whole application. And so, sure, it's open to the United States to say, well, Your Honour is now in the position of being able to look at the application and to look at the grounds. And on that point, it might be right to say Your Honour can decide that issue when the district court hasn't done so. It's in a different category from, there is sufficient basis for the court to say, I can now look at that issue and say, was there enough there to meet the requirements of the Bow Street filter?
Yeah.
Was there a reasonable basis for substantiation and so on, the 3 or 4 step test that's set out. And if Your Honour says none of those matters could have reached the standard that is laid down by Antonovich and Wilson, then of course we lose that argument. But we say that we did particularise, we did substantiate,
yes,
and we did do enough to require a hearing.
Yes.
And so really, Your Honour, the issue for Your Honour is, was there enough there to require a hearing? And if there was, then what comes next is a question of relief.
Sure. Well, I mean, one of the most critical aspects of the case, which is the 24(2)(c) question, I mean, Ms. Gordon quite fairly acknowledged that there's no adequate reasons given,
Yes.
or engagement on the submissions and the competing arguments in relation to those central issues. And that sort of problem, it's probably fair to say, does infect many aspects of the judgment.
Well, we say it does, sir, because if His Honour hasn't grasped properly the steps in Section 24 and hasn't got is asking himself the wrong question in the anismatic sense, then how can His Honour deal properly with the July stay application? How can he deal properly with the August stay application, let alone the eligibility?
Let alone the eligibility. Well, you're going to address the point that's been made quite forcefully by the United States that the case should proceed forwards, not backwards.
Yes.
And that even in relation to the bias allegation, this court can cure the defects because there aren't findings or anything of that nature that would present a difficulty in terms of answering that. When you make the point that, well, this is a case-stated appeal, but you'll be answering that point, will you, in terms of...
Yes, sir, and we will come back to Your Honour in our second set submissions directly on that issue.
Yeah, but do you agree that the case should be proceeding forward, not backwards? I mean,
it really depends what is meant by that, Your Honour.
Well, yes. To the next level in the appellate jurisdiction, rather than backwards.
I presume that could well happen, whatever I say and whatever I do.
Well, that's right. But,
well, sir, it is, we say, vitally important to follow the process that is laid down in the Act. The process that's followed in the Act is that this court is required to deal with the questions that have been posed and the reasons that underlie those questions. Yes. And so the first issue is whether Your Honour can deal with some groups of questions en bloc or not. The first question is, what did the district court judge err in law, and if so, in what respects? Now, once we get to that point, if we're at that point, and I'm not presuming anything, but if we're at that point, then the next question is relief. It's got to be.
Yeah.
And we then deal with that so far as the appeal procedure is concerned under Section 72 and Section 73. So that part of the process is dictated by the statute. And so far as errors of law are concerned, it is obviously correct for the court to deal with the appeal process as the predominant issue, even though the judicial review application is there as well. The appeal process is significant. But that doesn't mean the judicial review application is irrelevant, because under the beauty of the judicial review application is that the court can step back and take a broader approach in terms of what are the interests of justice. And one way in which the judicial review provides an advantage to the court is to be able to say, we have a cumulative effect situation. There is the cumulative effect of various things that have gone wrong. And you've heard our honour on the question of the innominate ground. Now, there are many cases where that simply doesn't fly, it's irrelevant, it doesn't help. But in a case like this, the underpinning reason for the supervisory jurisdiction of the court is to make sure that the rule of law is observed, that the principle of fair process is observed, and that where something has gone seriously wrong in a decision-making process, the result is one that is compliant with the rule of law. Now, what we say is, if you do what Mr. Ruffin proposes, which is throw away the JR, throw away the judicial review application, we don't need it. That deprives the court of the ability to step back from the situation and to deal with the decision-making process in a way that is just and right on an overall view of the situation. The case-stated procedure, we've been accused of asking for a blinkered approach to apply in relation to the case-stated procedure. But the case-stated procedure is inherently blinkered. It focuses on the particular questions of law that have been posed and the particular reasons that have been given. The judicial review enables a wider view to be taken. And so if and when the court reaches the relief stage, in our submission, it may be preferable for the court to say, there are errors of law, here are the errors of law, but in terms of relief, I'm not going to be limited or restricted or hamstrung, straitjacketed if you like, by the case-stated appeal process. I also have judicial review that enables me to take a wider view, and I'm going to deal with the question of relief under that heading. And that is particularly apt in relation to the Bennett jurisdiction. And I see the time, sir. I'll come back to the Bennett jurisdiction in due course. But what we say, sir, is that this court, as the court of having a supervisory role and supervisory authority over the case, this court has got the power to ensure that a wrongful result doesn't emanate from the case. Now, whether that means we're going backwards or forwards is another issue. It's a question of what is the appropriate relief to grant in this situation. Now, if you're with us, if Your Honour is with us on the July stay, and if you accept that the US will not change its position, then we'd get one result. If we move on to the August stay, the question is, should there have been a hearing? Should there now be a hearing? And then, of course, you've got there are three stages to it,
yes,
and those stages have to be looked at separately.
Yeah. quite right. All right, well, 15 minutes, thank you.
whakawa o te pini te koa, sawa te reira tōkia.
Yes, thank you.
Your Honour, if we can take you to page 8 of volume 2.
Yes. So you'll be explaining in due course why Ms. Hyde's tree is preferable to Mr. Ruffin's sapling.
Well, yes, Your Honour, and we could probably simplify that process. And I mean, it does look complicated in terms of the decision tree, but really, there are 3 stages to the process.
Sure.
And you go from one to the other, and then it's a question of relief.
Yes.
And although the parties, when Justice Asher was presiding, accepted that ideally the appeal process should be facilitated, we have never purported to fetter Your Honour's discretion as to the decision-making process, and we don't purport to do that now. It's a matter of judicial discretion in respect of which the parties have no right to dictate anything at all to Your Honour, and we certainly can't, by agreement, control the way in which you decide is the appropriate way to decide this case. We can make submissions, but we can't tell Your Honour what to do, and we don't pretend that we have that authority. Now, what that means is, in terms of the 3 stages of the decision-making process, Your Honour has to take into account all of the interests of justice, all of the relevant factors that are normally taken into account, and exercise an evaluation and a discretion as to how your judgment should be structured and what relief, if any, should be granted. We can't dictate the outcome. All we can say is that, yes, this is a big case, yes, it's likely to go on appeal, and yes, the Court of Appeal and possibly the Supreme Court will want to know as much of Your Honour's reasoning as possible. But that doesn't mean that Your Honour has to follow a particular decision-making course. We can only make suggestions on that. And I'm really not telling Your Honour anything you don't know already. I'm just acknowledging that point from our point of view. Now, so if we can go to page 8, in support, we say at 21, in support of the overall submission that the District Court was correct to uphold the preliminary objection, the United States makes 5 submissions. First, that the August-September stay applications were improperly brought with the purpose of diverting the District Court from considering eligibility. Second, the US is not responsible for the abuse complained of, and that such responsibility is a necessary prerequisite to granting a stay. Third, that Bow Street is not the correct inquiry. Fourth, that the District Court did not have any jurisdiction to hear the August and September stay applications. And fifth, even if the District Court did have jurisdiction, the allegations could never justify a stay. So those are the points to which we're now going to endeavour to respond. So far as the improper motives and delaying tactics point is concerned, we have set out in our pages 8 to 11 of volume 2 the reasons why we refute that allegation. We say that the August stay application was not brought for improper motives and was not brought for the purpose of delay. The grounds for the August stay application were clearly articulated in the application and the appendix, and those grounds were supported by an extensive affidavit from Mr. Ortmann. All of the grounds we submit had at least sufficient substantiation to meet the relevant requirements of the Bow Street filter. If I can just pause there for a moment and just clarify one point, sir. Ms Gordon, in her submissions, took Your Honour back to the transcript in the District Court and showed that I had acknowledged that the two applications were discrete and raised separate issues. That contradicted something that I had submitted earlier, which is that the essence of the July stay application had been included in the August stay application to allow the cumulative effect to be taken into account. I acknowledge, sir, that in the District Court I did indicate to His Honour that they were discrete applications, and we have no real reason to recoil from that proposition. They are separate, and the only reason that the point was repeated in the August stay was to enable the court to consider the cumulative effect. That is now an academic issue. Both applications were dismissed, and Your Honour has jurisdiction to deal with those applications afresh. So there is no point in arguing over that issue. But I accept that we did explain it to His Honour the District Court judge on the basis that they were discrete applications, and I overlooked the inclusion in the appendix of the July stay points. But coming back to our submission here, all of the grounds we submit had at least sufficient substantiation to meet the relevant requirements of the Bow Street filter. As we explain in our paragraphs 33 and 34, the desire for expediency or to end long-running proceedings cannot be allowed to infect the application of the law in this area. And to dismiss summarily an application which is self-evidently vexatious or frivolous is one thing. To dismiss an application which has apparent substantiation is quite another. Now, we're going to come back to that issue in our second reply submissions, but just pausing on the frivolous and vexatious point, Your Honour may have come across an article by Master Jacob back in 1970 entitled The Inherent Jurisdiction of the Court. It's a pretty well-known article, and in that article Master Jacob analyses the inherent jurisdiction of the court to dismiss summarily. It's a very broad-ranging article, but one of the points he deals with is the summary, the ability to dismiss summarily an application which is frivolous, vexatious, or an abuse of the process of the court. And it's part of the inherent jurisdiction, certainly in the High Court, and part of the implied powers of the District Court to be able to do that. The reason I mention it, sir, is because in our submission, the Bow Street filter is simply an application of that principle in the extradition context. It is a process that can be followed to weed out abusive applications and to send them packing on a summary basis. The court can consider an application and can say, this application is frivolous or vexatious or an abusive process, and therefore it will not be heard.
Is it really as narrow as that? I mean, the court has got a duty to ensure that its processes are not abused.
Yes.
Used to vex litigants, for example. So it's got an inherent jurisdiction, but it actually has a duty to exercise it to ensure that that doesn't happen.
Yes.
But those are extreme cases that you're talking about, where parties are not actually seeking to vindicate any perceived legal rights. It's a very narrow sort of circumstance in which that jurisdiction would be invoked.
And that's because...
Whereas so for example, well, it's a bit different potentially from applying the three-stage test indicated by Bowstreet, which goes a little further. For example, in the third step, to see whether there's a proper basis for it. It's even more than the requirement to properly plead fraud. You've actually got to show some evidence that there's a proper foundation for it, as an example.
Yes, but
I mean, is it really just as narrow as you've put it?
I'm not trying to say that it's a narrow category.
But that you would only ever knock back under the Bowstreet filter an application that was actually abusive, namely brought for the purpose of defeating or stalling a hearing of an extradition, for example.
I'm not trying to narrow it down in that way, Your Honour. What I'm saying is that the Bowstreet filter is a structured method of weeding out unmeritorious applications so that they don't clutter the extradition process. And that filter plays a similar role, not exactly the same, but a similar role to the frivolous, vexatious step.
Sort of more akin to a defendant seeking a summary judgment,
Yes.
isn't it? Showing that it just couldn't add up to a row of beans, including some consideration of evidence in appropriate cases.
Yes. I think, on reflection, Sir, that is a better analogy, that it is very similar to a summary judgment application. But it's similar but different. The beauty of the Bowstreet filter is that it is tailor-made for the extradition process. And although Ms. Gordon-QC is right in saying that the Supreme Court may not have gone the full distance in saying that is the law.
Yeah. Well, it didn't need to.
It doesn't need to. It's given it a level of approval which should help this court to say, well, it is a very sensible way to approach that situation. And that's really all you need.
I mean, it's quite a significant proposition to make that these applications were brought for a wholly wrongful purpose of derailing the extradition proceedings. I mean, they were signed off by senior counsel who presumably can be taken to have considered that they could properly be made, that these were genuine applications seeking a remedy to which their clients may be entitled.
Your Honour mentioned the fraud, allegations of fraud situation. You don't point the finger and say that something has been done for wrong reasons unless there's something to back that up.
A proper foundation. Yeah. And the mere pleading of it contains an implied assertion or confirmation that there is such an underlying foundation.
Also, we would not have made those allegations unless we thought they were sufficiently tenable for the court to rule on them. The other point about that is the decision in relation to the grounds pleaded is not a binary one. It is not a decision that is necessarily made across the board in relation to all of the pleaded grounds. There were, I don't know, maybe 10 or 12 different categories of issues in our August stay application that were set out in the appendices. Now, looking at those categories, is it appropriate for the judge determining the matter on an effective strikeout basis to say none of them are tenable? Or should the judge go through and look at each of the categories and say, well, I suppose to a certain extent His Honour did that in the judgment in the sense that there was a series of paragraphs, but they were very brief.
Yes.
And the level of analysis wasn't that deep. So what we say is you can't allege improper motives and delaying tactics unless there's evidence of that. And what you should do is to look at the grounds pleaded to see whether they are tenable in terms of what could meet the requirements of the Bow Street filter or whatever other test might be applied.
Well, they weren't struck out on the basis that they were abusive in the sense that they'd been brought for an improper purpose. I mean, that allegation wasn't made.
No. Well, it wasn't. Whether it was made in the district court or not,
Well,
it wasn't.
I don't think it was made in the district court, was it?
I'd have to check that, sir. I honestly don't recall. But the point is that His Honour didn't deal with it on that basis.
We didn't deal with it on that basis.
He just articulated a test and said that it didn't meet the test.
It just can't come up to the required threshold.
Yes.
And in his view, the touchstone was whether or not these matters could impede a fair hearing.
Yes. And so we say that the two categories have been intermingled in the test.
Sure.
So whatever the rights and wrongs in terms of the result, we say that the process that was followed was not up to the standards needed for judicial hygiene, or decision-making hygiene, I should say. Now, the next issue is US responsibility for conduct amounting to an abusive process. The United States says, well, we weren't responsible for all of the things that you complain about, therefore it's not our problem and you shouldn't be getting relief against the requesting state. Our response to that is that it's not necessary to show that the United States was directly responsible, but in any event, all of the activities of the officials in New Zealand was being carried out at the behest of the United States. And it's a pretty familiar scenario that an agent does something on behalf of someone else and that the principal is responsible. That's an issue that could be considered if the matter goes ahead. But in our submission, it can't be dealt with on a strikeout or preliminary objection basis. There is plenty of evidence that the US were involved in negotiating with the police. They were involved in the raid. They were involved in various stages of the process. Crown Law were acting on behalf of the United States. We know from the Dotcom disclosure case itself in the Supreme Court that while the Chief Justice took the view that the United States wasn't a proper party to the proceeding, all of the other judges took the contrary view. So the US is a litigant in this case, and Crown Law were acting for the United States as their client. So we say that's an issue that could be considered on the merits, but not on a strikeout basis. We got past that issue.
So you didn't need your discovery application granted?
I'm sorry, sir?
So you didn't need your discovery application?
I suspect that's a trick question and I might avoid it.
I'm only teasing you.
Your Honour, the United States, under this heading, deals with the Canadian Supreme Court case in the Schreiber litigation, in the civil case, in which the Canadian courts held that the German government was protected by the doctrine of state immunity. In our submission, that doctrine doesn't apply in the extradition proceedings, end of story. In these present proceedings and in the lower court, the United States is a litigant in our courts, as we've just discussed about the Supreme Court decision, and that's sufficient to enable the court to give or withhold remedies in this proceeding. Now, we go to paragraph 63. We there say, well, just starting at 62, the United States has not advanced any authority for the proposition that the August and September stay applications can only succeed if the plaintiffs can prove that the US was directly involved in the conduct alleged, so as to form the basis of the abusive process. And then at the end of its submissions on the topic, the US refers to a footnote to another judgment of the Canadian Supreme Court, which is the Barnaby case. And in that judgment, the court holds this: before disposing of this appeal, we wish to address Mr. Barnaby's argument that the minister applied the wrong test for abusive process. The minister stated that to find an abusive process, evidence of bad faith or an improper motive on the part of the foreign authorities is required. We agree with Mr. Barnaby that this was not a correct statement of the law. And then there's reference to another case, and the court said the abusive process also captures conduct short of bad faith that nonetheless risks undermining the integrity of the justice system. And we say that that statement is consistent with our position. The inquiry for the court, consistently with Wilson and Antonovich, is whether there is conduct such that continuing the extradition proceedings would undermine the confidence in the integrity of the judicial system. There's no need for that inquiry to find bad faith and improper motive or even direct involvement on the part of the requesting state. We say that others acting on behalf of the requesting state is sufficient. So we then go on to the question of the United States' involvement or responsibility at page 19. In that section, we demonstrate that if proof of United States involvement is necessary, we can show involvement in respect of each allegation in the August stay application. In essence, we say that the police were at all material times acting on behalf of the American government, and this includes the arrangement by the police for the surveillance carried out by the GCSB. In relation to that point, we mentioned that we've dealt with the documents issue, so I don't need to deal with that. Then we then come to a heading Evidence of US Misconduct on our page 21. The US submits that evidence of foreign state misconduct must possess special cogency. However, the plaintiffs were denied an opportunity to adduce evidence, so this is a premature point. The time to assess the cogency of the evidence is when the evidence is put before the court. So we say that argument is a non-starter. The US then refers to the requesting state's right to try a requested person. This is page 22. In this part of its submissions, the US asserts that it has a right to try the appellants in its jurisdiction. And we reject that analysis and set out our reasons at pages 22 and 23. The short point, Your Honour, is that the United States is a requesting state, not a demanding state. And any entitlement to try an accused person in an overseas jurisdiction is conditional upon the statutory requisites being met, including the duty of candour and any applicable treaty requirements. So it is an overstatement, and a serious overstatement, to suggest that the US has a right to try someone simply because that person is an extradition defendant. And we refer in particular to Article 9 of the treaty. We then deal with the application of Bow Street, page 23. The US submits that the Bow Street filter does not apply in New Zealand, and for the reasons we set out at pages 23 to 26, we say it does, and we rely in particular on the quotes set out in paragraphs 87 and 88, and Your Honour has seen those earlier. As I've acknowledged, the Supreme Court did not, in a conclusive way, rule on that point, but it certainly cited Bow Street with approval, and there is no apparent reason why that guidance should be rejected by this Honourable Court. We then come to the jurisdiction of the District Court, starting on our page 26. And for the reasons set out there, going to page 30, we submit that the leading case in New Zealand on the jurisdiction of the district court in relation to abuse of process is now the Supreme Court judgment in SEMA. That case considered at the highest level the jurisdictional or jurisprudential, I suppose, basis of the abuse of process doctrine in circumstances where the court in question is a court of limited jurisdiction, a creature of statute. And essentially in SEMA, the court held that the court has such jurisdiction as is necessary to enable the court to act effectively within its jurisdiction. There is no reason on earth why that Supreme Court judgment should be read down in relation to the extradition process, particularly when the Supreme Court has affirmed that the SEMA principle in relation to extradition proceedings, which it undoubtedly has done in the Dotcom case. So just as a matter of pure good old-fashioned stare decisis, we say SEMA and Dotcom, the Dotcom disclosure case, when read together, are now the fundamental cases on this issue. And it follows as night follows day that the earlier cases have been superseded just to such extent as necessary as to make them read consistently with the SEMA principle. So we deal with that issue in our paragraphs 99 and 100 down to 102. We set out the principles from SEMA at 99. We say at 100, the power to prevent an abusive process is therefore ancillary to the district court's statutory jurisdiction. That is under section 24 of the Extradition Act. And of course, Your Honour will recall that in the Dotcom disclosure case, mention was made, especially I think by Justice Glazebrook, of section 22 of the Extradition Act, which gives the district court the same powers and authority as a committal court. Now, if we need to go into the technicalities of the statutory powers and statutory powers of decision under the Judicature Amendment Act, the Judicature Amendment Act creates this regime of statutory powers and statutory powers of decision, and it includes decisions that are made by or under a statute. Now, the district court is a creature of statute. It only has powers to do anything because of those statutory provisions. And the decisions that it makes in relation to basically everything it does are statutory powers, including a decision to dismiss an application as an abusive process or frivolous or vexatious or whatever. So we say that implied powers that derive from a statutory power are just as much statutory powers as a decision directly made under an express provision of a statute. And there's a case, I think it's the Thames Jockey Club case, which deals with decisions that are made by or under a statute, and if Your Honour needs any assistance on that point, we can certainly provide it. Do we have Thames Jockey? We'll come back to that if necessary next week. The US submission that the power to stay proceedings, so at 101, the United States submission, however, is to the effect that the power to stay proceedings is ancillary to a distinct abuse of process jurisdiction. That is inconsistent with the current approach to inherent powers, as was carefully articulated by the Supreme Court in SEMA and expressly adopted in the Dotcom case. And we set out the relevant quote at the top of page 28. And the judgment of Justices McGrath and Blanchard, where they adopted SEMA. whether or not the district court has an inherent power to order disclosure either generally or in relation to specific material in the possession of a foreign state accordingly turns on whether it is necessary for the court to have such power to act effectively to prevent abuse of the court's process and to protect the fairness of the extradition hearing. And to similar effect is Justice William Young's statement recorded at our 103. Now, Your Honour, there is a little mini conundrum in this area, which is this. The US, in its submissions, distinguishes between jurisdiction and implied powers. And they say you can't have the latter without the former, which on the face of it makes sense. The court's got to have jurisdiction to deal with something before it can have implied powers. But the problem with that is that in these cases, the jurisdiction of the court is the subject matter jurisdiction. And once the court has got subject matter jurisdiction, it can then have implied powers to enable it to act effectively in relation to that issue. Now, what we say is that the extradition court has clearly got subject matter jurisdiction. It's a given. That's what it's there for. That's what it does. It's dealing with the extradition proceeding. Therefore, it's got the subject matter jurisdiction, and it doesn't have to have another kind of jurisdiction of the kind that's being advanced by the United States. It has subject matter jurisdiction, therefore it must have the implied powers to protect its own process from abuse, etc. So just trying to clear away what we say is an artificial distinction. The essence of the United States argument is to try to preserve two cases as current authority that bind both the district court and this court. And we deal with those cases at the top of page 29. They are Bujak and Police in D. And as you will see, the incompetent counsel who argued Bujak tried to convince the court that the Court of Appeal that the Horse Ferry Road Magistrates Court and Bennett provided a broader jurisdiction than Police in D and should be followed. The court rejected that. But that not very competent counsel, I think, we submit was proven correct in the later case where Horse Ferry was reaffirmed in Wilson. Now, the quote at the bottom of page 29 is to the effect that, which refers to the exceptional cases where an extradition judge might want further information to be sought from the requesting state, and such concerns would usually be resolved through dialogue between the court and counsel. And in such, this is a reference to Article 12 of the treaty. And Your Honour will recall that Ms. Gordon QC argued that in a situation where the court was concerned about an issue of candour, it can exercise the Article 12 procedure. But in the end, it's our understanding that can only take matters so far. And we say that what the Supreme Court is saying here is that this is a request for information. It's not a process that is designed to deal with the duty of candour. But over the page, there is a quote which from that part of the judgment where the court says, on this basis, exceptional circumstances will arise where there is evidence of abusive process of a nature that leads the judge to decide it is necessary to call for further information on an aspect of the application. And the court does say this may be the case where, for example, there is some indication of a lack of candour on the part of the requesting state. We would not, however, regard that as the only possible situation where additional information may be needed by the district court. So the Article 12 procedure can certainly be used to assist with the issue of breach of a duty of candour, but it's not a remedy. I guess that's the point I'm trying to make, sir, that it doesn't operate as a remedy. It's simply
part of the process.
Part of the process. Now, the next question is whether the allegations could justify a stay of proceedings. And despite the apparent approval of Bow Street by our Supreme Court, the US appears to contend that the Bow Street filter is inapplicable. We say that the court should reject that, and even if the Supreme Court judgment is not binding on the point, that approach is so sensible that it should be adopted. And we say that if it is adopted, then we pass with flying colours, to the point where a hearing should have been ordered and should now be ordered if necessary. We then deal with submissions on the grounds, the US submissions on the grounds of the August stay application. Those submissions demonstrate the difficulty of trying to assess the merits of an application that is not clearly frivolous or vexatious without hearing the evidence and making findings. So that's our general proposition. But coming down to the more granular level, unlawful interception of communications, and this is at our page 33. The United States submits that the GCSB episode does not relate to the proceedings before the extradition judge. And for the reasons that we explain at our 33 to 34, we say that the unlawful activities of the GCSB were directly relevant to the arrests. In particular, the unlawful activity of the GCSB in assisting the police was not disclosed in the ex parte application for the arrest warrants, and that is clearly sufficient in our submission to provide any necessary nexus. At 34, we deal with the unlawful surveillance issue, and we say that the same applies to the unlawful surveillance that was carried out by the police. That unlawful conduct was not disclosed to the judge who ordered the arrests, and it was an ex parte application, and the usual rules apply. Then, under the heading of breach of the duty of candour and good faith, when applying for the provisional arrest warrants at our page 35, the US submits in effect that there was no obligation to disclose the unlawful activities when applying the preceding unlawful activities when applying for the provisional arrest warrants. We say that that's inconsistent with the whole body of law in relation to ex parte applications, including in particular the recent judgment of Justice Clifford in the Hagar case. And I think we've already given Your Honour the reference to that, or it will be included in the body of our submissions. Now, at paragraphs 136 to 140, we refute the reliance of the United States on the decision of the Court of Appeal in 2013. We show in that section of our submissions that the Court of Appeal decision has nothing to do with the matters now in issue before the court. The US submits that invalid warrants would not affect the lawfulness of the extradition proceeding. We reject that submission and invite the court to consider the special statutory provisions that apply in relation to provisional arrest warrants under the Extradition Act. It is clear that an extradition proceeding cannot lawfully proceed if those procedures have not been properly followed. We submit, sir, that it's perfectly obvious that the arrest warrants are the cause of the plaintiffs being brought before the court in the extradition proceedings. If there was abuse at the arrest stage, there is clearly a sufficient nexus for the purposes of abuse of process. The decision of the House of Lords in Bennett makes that abundantly clear. The whole point in Bennett was that Bennett had been kidnapped and brought before the court on an unlawful process. And that didn't deter the House of Lords from intervening. On the contrary, they said that the courts had an obligation to uphold the rule of law in relation to that issue. And Bennett has been followed in New Zealand at the highest level, or approved at the highest level. So we say that argument, again, doesn't fly. We then deal with the unreasonable search and seizure point starting at our page 39. The US submits that there's an insufficient connection between the allegations of unreasonable search and seizure and the extradition proceedings. But Section 21 of the Bill of Rights provides protection in relation to unreasonable seizure of the person. If this is a point that's often overlooked about Section 21, if the plaintiffs were seized unreasonably, then that clearly provides a sufficient connection with the extradition proceedings, because the seizure resulted directly in the plaintiffs being brought before the court and detained thereafter. And also the US admits that information seized in the search and seizure operation has been included in the fourth supplementary ROC, and that point on its own is a sufficient connection to trigger the abusive process jurisdiction. Now we know that in the Supreme Court, in the disclosure case, Mr. Davison QC, as he then was, disavowed any attempt to lay a foundation for exclusion of evidence. But that was for the purposes of argument in that case, and it was not. There was no attempt to provide an undertaking on the point or do anything other than to limit the scope of the issues in that case for the purposes of that argument. And we say that that doesn't answer the issue, and it certainly doesn't fetter the discretion of the court in relation to the abusive process jurisdiction. We then deal with the unlawful removal of clones and denying the plaintiffs access to their own information, starting at page 40. On that issue, the United States has made a number of disputed factual allegations for which there is no evidence, as set out in our paragraph 147. The US also relies upon the Madeline Larissy affidavit, which is not in evidence in these proceedings. It is absolutely clear. Sorry, is that wrong? Footnote 34. I'm wrong about that, sir. I withdraw that reference to the Larissy affidavit. I've been corrected. It is absolutely clear that the clones were removed from New Zealand unlawfully, the courts have so ruled, and that the plaintiffs were denied access to their own information for a lengthy period when they needed that information for defence purposes. We explain in this section of our submissions that the US position on the issue amounts to nothing more than smokescreen tactics, and we submit that there was clearly a significant period of time when the plaintiffs were prejudiced by being denied access to their own devices. We then deal with some remaining grounds from page 44 onwards, and those points relate primarily to Mr. Dotcom, so I'll leave those issues to Mr. Mansfield. We next deal with the question of availability of alternative remedies, starting at our page 44. Now, at various points in its submissions, the US suggests that the August stay application did not need to be heard because there were alternative remedies available. But as we explain, whether alternative remedies are available and are more appropriate can only be considered after the issues have been heard and determined substantively. But in any event, it's difficult to see how an abusive process argument can be avoided on the basis of a mere possibility that alternative remedies could be obtained in other proceedings. It's not a strikeout point. It's not a point that could conceivably work in a strikeout situation. This is an argument that is sometimes used to deny a remedy in Bill of Rights proceedings, Bagent proceedings, for example, but the present issue is abuse of process. Remedy comes last, not first. We then deal, starting at 45, with the Bagent proceeding. In that section, we respond to the contention that the civil damages proceedings are the appropriate vehicle for resolving issues raised in the August stay application, and that the plaintiffs have been unreasonable in relation to settlement. In our submission, it should be obvious that the civil proceedings are no substitute for the August stay application, because it is only in the August stay application context or in the present judicial review proceedings that relief can be obtained in relation to the attempt to extradite the plaintiffs. That issue cannot be resolved in any other proceedings, and in particular, it can't be resolved in the civil damages claim against the Crown in right of New Zealand. That is a completely different kettle of fish, and we can't get an extradition remedy in relation to that proceeding. For a start, the United States is not a party to those proceedings. So it's a different stream, a different decision-making stream, and an alternative remedy in that proceeding cannot cut it. We then deal with the unreasonableness issue starting at our page 46. The question whether the District Court acted unreasonably in relation to the August stay application hasn't been addressed by the United States, and we say it hasn't been answered because, quite frankly, it can't be. The District Court did not act in accordance with the reasonableness or rationality principle in relation to that application. At page 46, we also deal with whether the High Court should order a hearing of the August stay application. We say that that question would strictly arise only if the Court were to refuse relief by way of a permanent stay of proceedings in relation to the July stay application. In that event, though, the Court would need to consider relief in respect of the August stay application if it was concluded that the District Court had failed to deal with that application correctly. If that point were to be reached, it's submitted that the better approach would be for the matter to be dealt with in this court rather than sending it back for a rehearing in the District Court, but we accept that Your Honour would have a discretion on that issue. Now, we then deal with what was in our original Part G, which is the question of eligibility for surrender, and there is really little need for me to go through chapter and verse on that issue. We've set out our argument in considerable detail. We again say that the US has ignored the District Court judgment and has instead gone straight to the question of whether the outcome was correct. But the primary question is not whether the outcome was correct, but whether the District Court erred in law in reaching that outcome, and we say it's wrong to skip that issue. Now, if Your Honour would give me a moment, I'll just see whether there's anything that I need to cover in detail. At pages 50 to 55, sir, we address the US approach in relation to 24.2c, and we submit that it's wrong to intermingle the accusation material with the evidential material. And we say that's a process that subverts the statutory test, and we draw your attention in particular to our paragraphs 188 to 189. We refer to the fact that in section 24.2c, the Act says that the offence must be an extradition offence, not that the evidence must constitute an extradition offence. In that context, the offence can only mean the US offence, and the offence must be within the genus for which the extradition is authorised. And so we submit that there's a danger of adding a gloss to the words of the statute. The foreign law label for the offence is not the issue, nor are the foreign law legal components, but the focus must be on the essential requirements of the charge as demonstrated in colour name. Otherwise, the words of the statute are in danger of being overridden by an impermissible reading up process, and importantly, section 24(2)(c) does not refer to the conduct constituting the offence. Now, in relation to the detail of the pathways and linking the particular counts to the what are said to be the correlating offences, we've set out our responses through down to page 97. We, at page 97, deal with specific errors of law arising under 24(2)(d), and there's a 10-page table. We need to reconsider that in the light of the more recent material provided by the United States, but we do point out that for many of the questions, the United States agreed initially that the district court erred in law. That was obviously inadvertent. It appears that the US position can properly be called a Freudian slip. I'm told that a Freudian slip is when you say what you're really thinking rather than what you were supposed to say. But in any event, counsel for the US have realised belatedly that, like the district court, they too fell into error and have now repented of the fact that they temporarily told the truth. But they still haven't addressed the district court reasoning. So far as the admissibility of the record of case is concerned, I'm sorry, just going back, I acknowledge, Your Honour, that the answers have been changed and that a new table has been, a new set of answers has been provided. I'm not suggesting otherwise. If I could just have a moment, sir. We deal, starting at page 110, with the admissibility of the record of case, the question of whether the certification was invalid for lack of candour. The US argument is that this is not a novel test case, but we say that they have failed to substantiate that point. The only US case cited is the hot file case, that is dealt with at the bottom of page our page 110. So we say at 373, in support of its submission that this case is not novel under US law, the United States relies upon 5 cases, only one of which is actually American. It's the hot file case. We reply to the United States submissions regarding hot file further on, to the extent that Griffiths, which is an Australian case, arises out of criminal proceedings. It doesn't support the US position for the reasons that we've already explained. And then the US, at 374, the US submits this. The point of these modern copyright conspiracy prosecutions is not that they were in the minds of the parties to the treaty in 1970. Obviously, they could not have been. Rather, they illustrate the breadth of the concept of conspiracy that the state parties agreed to. It undoubtedly encompasses copyright conspiracies such as this. Our response is that that submission is inherently contradictory. How can it be that on the one hand the cases could not have been in the minds of the treaty negotiators, but on the other hand they represent what the state parties agreed to cover in the treaty? And in our submission, this is a confused and confusing part of the US submissions. if we just go back to the hot file case, it is a civil case in the United States, which certainly does involve a claim for breach of copyright. It is an absolutely remarkable piece of forensic work on the part of Her Honour, the judge who dealt with that judgment. It demonstrates the complexity, the difficulty, the esoteric nature, the foreign nature, the inability of a New Zealand lawyer to grasp the nuances of US copyright law from a distance in a way that is difficult to explain by any other means. We've heard the phrase, a picture is worth 1,000 words. Well, an example is, in this case, is worth 1,000 words. Hot file demonstrates the very complexity that we have been endeavouring to explain, and the difficulty of getting a handle on the foreign law. It is not a simple matter. Hot file demonstrates in spades how complex, esoteric and tricky this area of the law is in the US jurisdiction. And I think we can say, sir, that the judgment in the court below suffers very badly by comparison. We then deal with the question of whether the record of case is a summary, as in accordance with the correct interpretation of Section 25 of the Extradition Act. That starts at page 111. The key point here is that the United States doesn't respond to our argument to the effect that the District Court didn't make any attempt to distinguish between summarised evidence and other material in the record of case and the supplements. And if we go to paragraph 377, Your Honour, I think, has seen that quote before, the underlined passage in 378 about conclusory assertions, and Her Honour's response to Counsel's contention that the record of case contained conclusory assertions. And essentially Her Honour is saying, well, yes, there are conclusory assertions, and they're either supported by proper evidence or they are not. That's the job for the extradition court judge to determine. Well, frankly, that exercise was not carried out by the court below. We also deal with the question, under that heading, the question of the suppression of witness identities. And if Your Honour would go to paragraph 385, the US submission that witness identity is immaterial to the summarised evidence at the extradition phase, we say is simply wrong. The US continues to ignore the fact that the extradition court must be satisfied as to, and the plaintiffs have the right to challenge, the availability of evidence. There's ample Canadian authority on that point in record of case situations where a certificate has been given that witnesses are available. It's improper for the prosecution to put that issue out of reach. A refusal to identify witnesses puts any such inquiry almost totally out of reach. Your Honour will recall that there are in the record of case, there's a series of references to alleged repeat infringers. Those alleged repeat infringers are referred to by initials only. We don't know who they are. There are numerous references to witnesses who are not identified. That simply puts beyond reach the question of whether those witnesses are still available, and we say that is not appropriate. We then come to the question of whether record of case evidence has been preserved at our page 115. it is clear, we submit, that the record of case and supplements referred to and rely upon a vast quantity of material that is or was on the computer servers that have been switched off and are unprotected from degradation. Professor Salas gave unchallenged evidence on the point, as did Mr. Rothkin. Obviously, they cannot say what the situation now is, but they can certainly say that there is a high danger of degradation in circumstances where the controlled ambient environment has not been kept as it normally would be in a computer farm situation. We say it's therefore obvious that the evidence allegedly summarised in the record of case has not been preserved for trial. How can the United States say in one breath that it has witnesses who will give evidence about the files that were on the mega upload servers, and in the next breath say that those files are not part of the evidence that needs to be preserved? We say it's one or the other. If the computer files are outside the scope of the evidence, then how can the proposed witnesses prove their identity and status? In other words, the identity and status of the files. And how can there then be a prima facie case made out? But if the computer files are within the scope of the summarised evidence, how can they then say that the evidence has been preserved when clearly it has not been? We say that that is sufficient of itself, either to destroy the prima facie case argument or to make the record of case and supplements inadmissible, which amounts to the same thing, because without the record of case, there is no evidence. We submit that the certificate is plainly wrong, and Mr. Prabhu has not been candid on the preservation of evidence issue. He didn't disclose anything about the servers being switched off and not preserved. The record of case, we say, is therefore inadmissible, and if that is so, then there is no evidence before the court to establish eligibility. We then move on to the question of copyright law and transposition under the Part G analysis, that is the eligibility analysis. In our submission, the United States fails to give any adequate answer to the plaintiff's submissions on this issue. Instead, the United States sticks to its own cover story, which is that the concept of transposition eliminates any need to prove copyright and infringement. In fact, there is no authority for that proposition in circumstances where a prima facie case has to be established. The only case that refers to copyright being a state of things that didn't need to be proved is Griffiths. That's the sole authority on that point. And as we have seen, that statement was only in respect of whether the US had established an extradition offence. There was no requirement to establish a prima facie case, and the court said that copyright ownership would have to be proved at trial. Now, the fact that I don't read out specific points shouldn't be taken as any indication that we're not relying on our written material. We obviously are. But I don't think that there is any need for me to read particular passages or draw your attention to anything else for the rest of the material in relation to Part G. That takes us down to Part H, which is the case stated procedure. As Your Honour knows, that's not now pursued as a separate cause of action. It will be dealt with in relation to the bias and predetermination argument. And so far as that argument is concerned, we developed that argument more fully in our, or more accurately, I should say, in our second set of submissions. And so I'll pass over that material for the moment. And we'll come back to Your Honour on that issue next week. In short, we say that the United States has not dealt adequately with the Saxmeer Observer analysis. there are only five strands of the US argument, which are the order followed at the hearing, the allegations of inattention, extent of questioning and demeanour, the inclusion of the US submissions in the judgment, the cut and paste issue, the alleged errors of fact and law in the judgment, and the treatment of the case as stated. Those are the 5 points on which the US responds. There is no overall response to Mr. Spring's Saxmere Observer point. And then, so we pass over that for the moment, sir, and come back to it next week. Then the two final sections are the anominate ground and relief, which, I'm sorry, and then the US strikeout application. In view of the time, sir, it's
If that's a convenient time, we can adjourn.
preferable to come back to that on Monday.
All right. Well, we're going very well for time, actually, aren't we?
Yes, we
You'll
are.
finish on Monday. Do you think or not?
The 12 September submissions ran to...
Oh, no, look, I'm not wanting to...
No, I just
hurry
want to give
you
Your Honour an indication. So
Yeah.
there are about 100 pages of new submissions that we had to respond to. The transcript of Ms. Gordon QC's submissions runs to 600 pages. So I'm not necessarily saying that we will finish on Monday.
All right.
We could run into... we are likely to run into Tuesday, sir.
Yes, but you'll finish on Tuesday.
I'll certainly
at some
finish on
point.
Tuesday, yes, sir.
And Mr. Mansfield, you'll be ready to go?
Ready and rearing, sir.
Ready and rearing?
Yes.
All right. All right, well, that's fine. Okay, all right, well, thank you very much.
you.
We'll adjourn until 10 o'clock Monday.